So it was on when we didn't want it on.
It's on now.
Back.
It's on now. Okay, fantastic. Well, good morning, everyone. Welcome to 2021 and the first
I think-
Court of Appeals.
Yeah, I believe Julie has it fixed, Your Honor.
Okay. Then how about this? I'll just wait for you to tell me when to start, when everything is all in play, okay? So I'm relying on you to let me know.
I think it's ready, Judge Sias. I'm looking, he's on mute right now.
I mean, it looks like it says live.
I think we can go ahead.
All right, well, good morning again.
Good morning.
And happy New Year to everyone. Hopefully 2021 will be healthy for everyone. So we're here at the First District Court of Appeals. We have one case set for argument this morning. It is case number C19-0419, State of Ohio versus Cameron Smith. If each side can identify yourselves for the record, please.
My name is Laura Peters and I represent the appellant Cameron Smith.
Thank you. Good morning, Lori. Laura.
Tyler Liston, I represent the city of Cincinnati, the appellee.
Okay, Tyler. So whenever you're ready, and Attorney Peters, would you like to reserve some time?
Yes, I would like to reserve 3 minutes, please, Your Honor.
Okay, 3 minutes. Whenever you're ready.
May it please the court, Mr. Liston. As I just said, my name is Laura Peters and I represent the appellant in this matter, Cameron Smith. This case began with a Facebook, but if the state would have its way, it should prove as a warning to all Facebook users to be careful what you post to your Facebook page, because anyone who might feel threatened by your content could potentially have you charged with telecommunications harassment. In this matter, Mr. Smith sent a friend request to the grandmother of his son. During the time that friend request was ignored for a certain period of time, which is it's unclear on the record exactly when he sent the Facebook request. It could have been as early as December of 2018, or it was sent in February, or as late as February of 2019. What is also clear in the record, however, that
So we don't know exactly when the friend request was sent?
What we know is that the friend request was sent 15 weeks before the screenshot was taken that makes up Exhibit 2. She testified to a number of different dates as to when she actually took the screenshot. The first time she testified that she took the screenshot the day of trial, which would have been May 24th. But also the email, it was actually an email to the prosecutor. So the screenshot would have at least been taken actually of May 21st, because that's the date of the email when she sent it to the prosecutor. However, during trial, she also said that when she went to the police, she took the screenshot with her. So when she went to the police was March 22nd. So that's how we know that there's a discrepancy in the timeline. But what
Right.
we do
No,
know,
I understand the discrepancy in the timeline, but where's the 15 weeks come from?
the 15 weeks, if you look at Exhibit 2, Your Honor, it states that, so what you see is the friend request, and it just basically has a profile picture, which shows a man with her grandson, and it has the profile name, which in this case is Pablo Money Train Esco, and then underneath that it says 15 weeks. And the witness did testify that it was indicative that the screenshot, that the friend request that she received was at least 15 weeks earlier than the screenshot. So, but regardless of actually when the screenshot was made, in this case, we also know, which she testified to, is that what she was really concerned about was not the friend request in Exhibit 1, because there is nothing in the friend request itself that can be deemed to be threatening to her, that it was intended to cause her alarm, or and in this case we're limited to not to threaten, because that's what the complaint charge was, that he sent the telecommunications with a purpose to threaten Miss Farrell. So there's absolutely nothing threatening in the Facebook friend request itself, because it's just, again, a picture of Cameron Smith holding her grandson with his profile name. And it asks her whether to confirm or to delete. So she had three choices at that point in time. She could either confirm the friend request and that would conclude it, or she could delete the friend request and that could conclude it, or she could do what she has done, is left it pending, which, so in no way is there anything threatening about the actual friend request that was sent to her.
When the friend request was sent, was the background picture at the one at issue with the firearm, was that at play?
No, Your Honor, actually it was not. And she does testify to that on cross-examination, that she realized that the cover photo with him with the gun was changed during the time period that friend request was pending. So when he sent when he sends the friend request, we don't even know, and the state hasn't proven what the cover photo on his page was. But again, even if you consider that this was his cover photo, it's him. You can't even see the face of the person holding the gun.
Does the record establish when the cover photo was posted?
I believe it talked about as potentially around February 27th. So it was sometime before, again, sometime before the friend request. And at trial, when she calculated the 15 weeks from the date of trial, she said that it was February 5. I calculated that if you go back from her earlier time of March 22nd, then that leads you back into a December date.
Can I ask you a clarifying question? What
Yes,
would
Your
appear on the friend request is a profile picture, and the cover photo would not appear on friend request. So, and you're making that distinction, correct? What she got in the friend request was his profile picture, and what she considers threatening is the cover photo.
Correct, Your Honor.
Okay, that would appear to any of us online if we went and sought him on Facebook.
Correct, Your Honor. So she did not even need to get a friend request to be able to look at his Facebook profile page, because at the time his was public. And so that cover photo, that's the problem in this case, Your Honor, is that anyone who went to his Facebook profile page would have seen the cover photo with the gun being pointed at the camera and with the text underneath the profile name of "no drive-by, this personal hit you close range." However, Your Honor, what we also know, or what is that nothing on the cover page or on his profile page was actually directed at Miss Farrell. It doesn't say anything about, "Hey, Grandma," or "Hey, Miss Farrell," or "Hey, Anna," or there's nothing in relationship. It's him actually posting a song lyric from the song by Kodiak Black and Jack Boy in the song G to the A.
So would the analysis differ under your theory if, for instance, she had been tagged in that picture?
Yes, I would, because that would be some link that would show that he had a purpose to link her to that photo. This is him expressing something that's of interest to him. Lyric and gun.
Well, and I guess, your opening point about the sweep of this issue, I mean, are there First Amendment concerns here? I didn't see any kind of First Amendment argument in your brief.
No, because I think the First Amendment would apply to, doesn't apply to threats. But we have to look at as whether or not he's actually making a threat here. And I would say, I don't see that this is making a threat to anyone specifically. And that's the point of the statute. The statute has a very high mens rea element to it. It has to be done with purpose to threaten Miss Farrell. And in this case, there was absolutely no evidence, Your Honors, that this was done, that he posted this photo, that he posted that song lyric to threaten Miss Farrell. The only thing specifically directed at her was the friend request. But again, that's not something the friend request itself is not threatening. It doesn't, if she had never clicked on his profile page, she would have never seen it. So you can't necessarily link the two. And I think that there's also a problem when you talk about Exhibit 1 as being the basis for the threat, is that this is not a telecommunication. A telecommunication is something that is sent, disseminated, transmitted. This is a posting on a website. So that's the point in our brief where we argue that the applicable statute to deal with charging him with telecommunications harassment for what appeared on his Facebook profile page.
Wasn't the B section purpose to threaten? That was the only section that was charged in the complaint.
The B1 section was charged, and that involves making a telecommunication.
Exactly,
The
with the
B2
purpose.
section is posting on a web page, which
Right.
is,
So what I'm saying is that the B1 section was what was charged in the complaint. And did the prosecution ever amend that?
no, Your Honor, they did not. So that's why we argue that, again, the evidence is insufficient to prove that he committed telecommunications harassment under the B1 section, which was with what he was charged.
Under your argument, to follow it through, anyone that he sent a friend request to might feel threatened if they saw a cover page with that caption and that gun. So for example, if he sent me a friend request and I happened to click it on, under your theory, the state would be able to charge him with threatening me or you or Judge Zayas or Judge Bergeron just by the act of sending the friend request.
Correct, Your Honor. So he could have sent this friend request to 5 different people, and Ms. Farrell being one of them. So Ms. Farrell, because she quite admitted that she disliked my client because of the relationship, the volatile nature of the relationship that he had with her daughter, not necessarily with her. This is that she doesn't actually really reference except for one incident that occurred and which she placed 2 months before she received the friend request. If you don't have a beef with him, you wouldn't even question this, but she's using this to say, oh, I feel threatened. But actually in Hamilton versus Combs, which is cited in my brief, it doesn't matter exactly what she felt, how she felt about the threatening. It's what is the key element here is what was his purpose. You can't establish that his purpose was to threaten Ms. Farrell when we actually don't even know what the cover photo was. If you're relying on the cover photo, the friend request itself, again, is not threatening. So you can't use Exhibit 1, or sorry, that's Exhibit 2 is the friend request, to say he committed telecommunications harassment by threatening her, because friend request is not a threat.
Now, ultimately, the complaint seemed to be pointing to Exhibit 2.
Correct, Your Honor. And again, the Exhibit 2 is posted to his Facebook page. It wasn't a telecommunication. This wasn't sent to her. She looked at his profile page and saw this.
Did the state ultimately argue, particularly at closing, that it was Exhibit 1 that created the threat and it was intended to lead to Exhibit 2?
Well, I mean, if that's what they are, I mean, that would be backwards, because the friend request leads you to potentially to Exhibit 1, which is the cover page.
Maybe I confused them. Exhibit 2 is.
Yeah, it's kind of backwards. The friend request is Exhibit 2, and the cover photo is Exhibit 1.
So the complaint was charged on Exhibit 1, which is the background.
Correct.
Photo.
Yes.
But the state, didn't they change their theory to argue the friend request as the basis of the threat?
They might have, but they might have been trying to say that, because he sent a friend request, that it provides a link to his profile page, but she doesn't have to click on that link. The link itself is not a threat. So you can't say, again, I would argue the friend request itself is not a threat. It's not done with purposes of harassment. It sat there for 15 weeks, or it sat there. She has other friend requests. So, you can see an exhibit.
If you want to wrap up so that I can reserve your 3 minutes.
Okay. Yeah. So Basically, what we're arguing is that there is insufficient evidence to prove that there was a telecommunication with the purpose to threaten. We also would argue, if there's any questions on the other assignments of error, like 2, 3, or 4. Okay, we would
We'll
just ask
serve you
this
3
court to
minutes.
reverse and discharge Mr. Smith. Thank you.
Okay, thank you. Good morning, Attorney Liston. How are you?
Good morning, doing well.
Whenever you're ready.
Ms. Peters and your honors, may it please the court. The state would largely agree that, well, we'd entirely agree that the feelings of the victim are irrelevant in this case, and that what matters, of course, is the purpose or the intentions of the defendant who is charged. Now, largely to address the entire argument that's been so far in the record, that relies on the fact that the friend request itself could not be threatening. And we're unwilling to concede that position. This is
Well, why don't I stop you right there? I mean, are you trying to argue that the friend request by itself constitutes a threat without regard to the profile picture of him with the gun?
the crux of my argument will be that is an invitation to view. But I think that even if that is not taken to be true, if it's the friend request alone, I think that still is enough to rise to the standard that's needed here.
But the friend request was sent before he had changed his profile or the cover picture.
So I want to,
if it, under your theory, the invitation to view, if she had clicked on it at the time that he sent it, she would not have seen the threatening picture, right?
well, I want to clarify, I don't believe that the record supports that. And I see the part that's being referenced there. The only time that some sort of date was offered as to when the picture was actually put on there was offered as part of a question posed by defense counsel. There's no evidence that that date was correct. It was just, would you agree that it was put up this date?
So what was the evidence that the state presented to establish that the cover photo pre-existed to the friend request?
In the record, Your Honor, the state never offered evidence. They do not have access to that kind of data. What the state puts forward is that, viewing this in a totality of the circumstances, considering everything together, that his actions of reaching out to her were meant to threaten. And that's supported by what was on his page, but not only everything that happened leading up to this incident.
Is it your position that anybody he sent a friend request to during that period of time, he was meaning it as a threat?
Thank you. No. So what separates this victim from every other person who could view his page voluntarily or that received a friend request would be the nature of the relationship leading up to it. The fact that the defendant had been blocked through all other lines of communication, the fact that the defendant had previously threatened the victim, the fact that there are physical altercations occurring between the victim's family and the defendant regularly. These things, when put together and viewed, and if believed, can support the finding that the trial court made, which is that this is the defendant threatening the victim. As I said, it had been previously established. He had done verbal threats to the victim before. She blocks all of his numbers that are associated with him. He has trouble getting a hold of her. There's one means available to him.
I guess I'm having trouble with your notion that a friend request in and of itself can be threatening, because it is not like a phone call where you have to answer it. I mean, I get friend requests from random people that I just ignore. And, to say that the simple act of sending a friend request constitutes a threat, that seems pretty sweeping to me.
Yeah, so I think that, of course, it's everything viewed together. But in that light, it's also true that it wasn't his name that was on the profile. It was Pablo Money Train Esco. That's not his name. And so someone who is looking through their Facebook wanting to know who has asked them to be their friend would potentially open up someone whose name they don't recognize.
Is there evidence in the record that she knew that that name was associated with Mr. Smith?
Your Honor, I think that she says her daughter had tagged or been tagged by that name. So in that light, I believe that could be. Again, this record is somewhat convoluted as to specificity like that. It doesn't appear that the testifying witness for the state knew much about Facebook. And as to the dates, I believe it was pretty convoluted as well. And so in that regard, and of course here,
And
we
I
have
do,
to,
and I understand, I understand where you're coming from, to establish the purpose. Sometimes it's very overt, but most of the times it is, and then one looks at the totality of circumstances. But ultimately, doesn't there have to be a connection between the threat and the victim? So in this case, what would be the connection, in this case with a profile picture, because that's really where it seems that the threat is rooted in, and the victim.
yes,
Not
so,
profile picture, pardon me, the cover picture.
right. So here, the state treated at trial, and of course now, that the page that was created is containing threatening images in itself. But then the friend request acts beyond what normal or regular friend requests do and acts as an invitation to view a threatening page. But it's that invitation and that attempt to reach out to a victim who is taking efforts to restrict contact, blocking phone numbers, telling them they're no longer allowed to come to her house. Now, all of a sudden, that person takes the steps of reaching out through a friend request. His means are limited. The defendant's ability to reach this victim has been restricted. He goes through what he has. It's this friend request.
Well, but by that logic, people can have a lot of pictures on their Facebook page. And so let's say this picture was down at the bottom of, dozens of other pictures. Like, is that, I'm just trying to figure out like where we draw the line on something like this when on the invitation, because of all the other pictures that are non-threatening, there's one at the bottom that someone could perceive as threatening. Like, how do we deal with that?
Yes, I would see this as likened to perhaps a website that was set up with these images on it and then a link being sent to the victim. I think in that situation, it's more clear, but because it's through Facebook, a medium we know and use regularly in a much different way than here, we somehow see it as different. But what is really being offered here is that link. Here are the threatening images. It's not at the bottom, it's his cover photo. The photo is him and the victim's grandson, admittedly his son, but something that would cause the victim to recognize and click on this link in a period of extreme tension between the defendant and the victim. I think that is what is essential, and that's why there's so much transcript dedicated to it. These are tumultuous times that in the middle of, the defendant sends a friend request. And I believe it is in mitigation, they discussed that friend request was an attempt at camaraderie, or he just wanted to reach out to see his son. If we view this as if the trier of fact had the best seat to view the facts, and if we believe the evidence, and if we defer and see it in a light most favorable to the prosecution, I don't think it is clear that the trial court lost its way in determining what it did. It sees a tumultuous period in the middle of which the victim is getting a friend request from someone who alleges they want to be friends. It was clear to the trial court what that friend request was. Again, they had known each other for 10 years. All of those 10 years, the victim had a Facebook page. It was only after being kicked out and having these other threats that he receives this, or I'm sorry, that she receives this Facebook invite. The first time from the father of her grandson is while they're fighting, while contact has been limited, while his numbers have been blocked. Your Honors, I believe we should defer to the judgment. I believe we should leave it as stands. The trier of fact heard these facts and was convinced that this defendant intended to threaten the victim. As to the third assignment of error, referencing the court's use of a different mens rea, I think that it is clear that, well, what's clear is that it's unclear, that that's a response to a question or a statement posed by defense counsel, at which point the court responds indicating that, which attempts to clarify the language used by the defense counsel. Admittedly, it's not very clarifying. It further muddies the waters, but I don't think it at all overcomes the presumption that he followed the law or that he knew the law. I believe that at best, he's attempting to explain what was posed by defense counsel. And furthermore, I don't believe that defense counsel had acted in a way that was ineffective. There were multiple points throughout the trial where she argues the correct standard. And then in closing argument, the only time she fails to mention the necessary intent, what she does is she locks in on knowingly, and specifically that the telecommunication has to be made knowingly. I believe that
Ultimately, even if there was a deficiency, this was a bench trial, was it not?
it was a bench trial.
So what would be the prejudice, if any?
To the bench trial, none. Even if it was argued incorrectly, because we're presuming that the judge knew the law and followed the law, it would be nearly impossible to overcome the second prong posed by the standard in this case. So let's see. That being said, the appellant's burden is high, and the evidence here is more than enough about the relationship and the nature of the relationship between the parties. And it's in the midst of that this friend request is sent. I believe that is enough for the judge's ruling to stand, and it is not enough to overturn. So I would ask this court to affirm. If there's no additional questions, I will stand on the merits of my brief.
Thank you, Attorney Liston. Attorney Peters, you still have your 3 minutes.
Thank you, Your Honor. I would just like to respectfully disagree with Mr. Liston about the evidence establishing clearly that this was during a tumultuous time period between Ms. Farrell and Mr. Smith. The friend request, as I said, was sent the latest it was sent was February 5. The major incident that Ms. Farrell was concerned about, in which she was saying that this is the basis of why she believed this was a threat, was that she alleged that my client broke her daughter's jaw the day before Valentine's Day. This is not some amorphous date as the state seemed to indicate in this brief. She clearly pinpointed this as the day before Valentine's Day. The friend request at that point in time had already been sent. So you can't even consider that, because again, it has to be what he did. What was the purpose when he sent that friend request? What was his cover page at the time? So if you're arguing, since the state is arguing that the link was important, that the friend request, now this was some type of unusual friend request, because that friend request appears the same as anybody else. It has his profile picture, his profile name, and it has confirm or delete. There's nothing different about that friend request from any other friend request that you can see in Exhibit 2. So when he made that friend request, if you're talking about the link, you have to know what the cover photo was. And the state just admitted it does not know, and it didn't put on evidence as to what the cover photo was at the time that he sent the friend request. And yes, Ms. Farrell did testify. She agreed with the question. Yeah, that's right. When the question was asked, do you realize that this cover photo was changed on February 27th? Yeah, that's right. So she is agreeing with the statement made or she's agreeing with the proposition in the question. So again, I would argue that there is nothing directed towards Ms. Farrell in Exhibit 2, which is not itself, I'm sorry, Exhibit 1, the cover photo and the text, which again is not directed specifically towards Ms. Farrell in any fashion. And the history between them, she testifies to one example where she alleged that he threatened her, and that happened in November or December. And in between that time, who knows whether or not he had a better relationship with the daughter at a certain point of time. She doesn't really testify to that. She just says there was this incident that they were constantly kind of back and forth, where the daughter was moving in and out of her residence and in with Mr. Smith. So this was never an instance in which Mr. Smith was kicked out of Ms. Farrell's residence. There's nothing, she doesn't testify to any direct exchange except for that one incident in November or December, which again was there's sufficient time, like to say, it's would seem to be a little not connected necessarily with the friend request. The friend request, again, you just say it's not a threat, that that this evidence is insufficient, and even if you would construe taking the circumstances, it's definitely against the manifest weight here.
Thank you for
Unless
your
the panel
arguments this morning.
Okay,
Thank you for both of your arguments this morning. We'll take the matter under submission and issue a timely decision. And as this is our first panel and our first argument for 2021, I wish you the best in 2021.
thank you.